So we need to talk about a new case heading for Supreme Court oral arguments this upcoming week. This case attempts to build off of a prior 9-0 unanimous decision by the Supreme Court, which impacts our rights to prevent the warrantless entry into our homes. Now, before we jump into this video, I want to ask you guys for a favor. If you want to support the channel, one of the best ways to do that, of course, is to subscribe to the channel. Also, double check to make sure YouTube is not unsubscribed to you, because they love to do that, especially on 2A channels. And I would love to, maybe try to reach 900,000 subscribers before the end of the year. Kind of far off, but it would be cool to do that. And I would love your guys' support. Now, as I mentioned in the intro, in this video, we're going to be discussing a new Supreme Court case that was granted review, and it involves when police can enter someone's home without a warrant. This case tries to use a prior 9-0 unanimous decision issued by the Supreme Court, which involved the warrantless search and seizure of firearms within the home. This new challenge pending in front of the Supreme Court is called Case versus Montana. This challenge is important for gun owners, especially because it involves when law enforcement can use legal workarounds to not only enter your home without a warrant, but also potentially confiscate your guns. This case is now set for oral arguments, and it's going to happen next week on Wednesday, October 15th. Also very interesting in this case, the Trump administration was recently granted permission to participate in those oral arguments, and they will argue in support of the state of Montana and their position in this case. Now, this challenge attempts to use and expand upon a prior unanimous ruling by the Supreme Court in a case called Caniglia versus Strom. Now, the facts surrounding this specific challenge here involves Mr. Trevor Case, and Trevor's ex-girlfriend called police saying that he called her and that she had a bad feeling about some of the conversations that they had. And when her and the police officers arrived at his house, she told them that she could not remember exactly what he said, but that she had a bad feeling and that he maybe would have a shootout with the police officers. And when the 4 police officers arrived at the home, they looked through the windows into the rooms. They did not see Mr. Case. One of the police officers noticed that there was an empty handgun in a holster and a notepad. And the police officers knocked on the door, shined flashlights through the windows, called for Mr. Case, but he did not respond. And essentially, after 40 minutes sitting outside the home, the police officers decided to enter the home through the front door, which was unlocked. When the 4 police officers entered the home, 2 of them went upstairs and one of them entered an upstairs bedroom. And when entering that bedroom, he saw a closet curtain jerk open. The briefs claimed that the police officers saw the curtain jerk open, and they claimed that they saw Trevor's face and what the police officer believed was a black object. In response, the police officer shot at Trevor in the closet, hit him in the arm, and then passed through and hit him also in the abdomen. Now, in contrast, Trevor and his family state that the police officer, when entering the room, saw the closet curtain jerk open, and in 0.4 of a second, fired a single shot at that, closet curtain. That was likely not enough time to see Trevor's face or a black object, but instead it was likely an accidental or startled response. In fact, the police officer also stated on the scene that he saw the curtain moving, and in his words, he then just let one fly. Now, in response to all this, Trevor argues that the officer's warrantless entry into his home violated the 4th Amendment, so the gun and other evidence should actually be suppressed. Now, those arguments were rejected by the lower courts and eventually also rejected by the Montana Supreme Court in a 4-3 split decision. This challenge has now made its way to the United States Supreme Court and was granted review, and oral arguments are going to happen in this case next week on Wednesday. The question presented to be decided by the Supreme Court is whether law enforcement may enter a home without a search warrant based on less than probable cause that an emergency is occurring, or whether the emergency aid exception requires probable cause. Case also argued that the search was not justified under the community caretaking doctrine, which was also struck down by the Supreme Court recently in a case called Caniglia versus Strom. Now, if you're not aware of what happened in the Caniglia case and why this is important and why they're trying to expand upon that ruling, essentially in that case, a husband and wife got into an argument, and during the argument, the husband got out a handgun, put it on the table, and told the wife, "Why don't you just take it and put me out of my misery?" Now, after that, the wife decided to leave the house, stay at a hotel overnight. The next morning, she tried to call her husband. He didn't answer, and so she called police. Her and the police officers arrived at the home the next morning. They found that Mr. Caniglia was on the front porch. Nothing was wrong, but the police officers were still concerned about the husband. And because of that, the police officers recommended that he go to the hospital for a psychiatric evaluation. They took him to the hospital, but before doing that, Mr. Caniglia had a conversation with the police officers, and he told them that he did not consent to them taking the firearms in the home. He did not want them confiscated, and the police officers agreed that they would not take the guns. Now, what ended up happening is after Mr. Caniglia left the home to go to the hospital, the police officers essentially lied to the wife. They went to her and said that your husband did consent to us taking the guns. Believing that he did say that, the wife allowed them into the home and they took all those firearms. And that led to the case being, filed. A lawsuit eventually made its way all the way to the Supreme Court. And in 2021, on review, the Supreme Court issued a rare 9-0 unanimous ruling in favor of Mr. Caniglia. The Supreme Court struck down the community caretaking rationale used to enter the home and seize those guns. But now the Supreme Court will step back into these issues and hear a case next week. Now, in this challenge here by Mr. Trevor Case, recently the Trump administration filed an amicus brief in support of the state of Montana's position. Now, in that brief, the Trump administration argued that the Fourth Amendment standard in these emergency aid cases should be reasonableness, not probable cause. They argue that probable cause attaches only to warrants, not every single type of search or seizure. And since emergency aid entries occur without warrants, the only requirement is that they be reasonable under these circumstances. That means in this case, the Trump DOJ and the Trump administration is arguing for a lesser reasonableness standard for these types of emergency aid situations instead of something like probable cause. In this case, the Supreme Court also has now permitted the Trump administration to join those oral arguments on Wednesday, so the Trump administration will be able to argue in support of the state of Montana and the whole reasonableness test that Montana is trying to use to justify these actions. Now, Mr. Case recently filed a reply brief, and he argues in that this court has refused to adopt a third Fourth Amendment threshold between probable cause and reasonable suspicion, and a vague reasonableness test is an especially poor candidate for that type of approach. The officers, firefighters, social workers, and paramedics who assess emergencies need the relative simplicity of clarity provided by probable cause, not a rule that confuses even its own proponents. This court should adhere to the textual and traditional standard of probable cause. Now, Mr. Case's attorneys also point out in the reply that even the Trump administration and the state of Montana in their briefs differ in their approach on the whole reasonableness test. They don't even agree on how to apply this. And based on that, he argues that the Supreme Court should reject the whole reasonableness test and instead maintain the probable cause and reasonable suspicion tests, even in these type of emergency situations, especially when you're dealing with the home, which should be treated as your castle. Now, this is important because it impacts everyone's protections against these type of warrant exceptions. The Supreme Court now has an opportunity to clarify or expand upon that prior 9-0 unanimous ruling by the Caniglia case, which could have direct downstream implications on what protections we all have from police officers and the federal government and other officials from entering our homes under the whole warrantless search and seizure exceptions in these type of emergency situations. As I mentioned, oral arguments are now happening this upcoming Wednesday on October 15th, but it's also interesting that the Trump DOJ is now going to be able to participate in those arguments and argue on behalf of the state of Montana. Now, this week, we're going to get a lot of information from the Supreme Court based on the hypotheticals and the questions that they asked. We should be able to get a good idea about how the Supreme Court is going to approach this case, and so we're going to be watching and listening to those closely to figure out how are they going to handle this situation. As we get more information, as it develops more, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that, of course, is to subscribe to the channel. That, of course, helps the channel to grow. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.